Good morning. It's Friday, the 25th of July, and welcome to the Borderlines podcast. We are talking today about Bill C-2. It's something that's been looming over all of us for several weeks. We've just been kind of circling the wagons and figuring out how to tackle this giant bill. And so we've decided to just dive in. I figure that this is, and both of us have decided this is going to be something we're going to have to talk about multiple times because it's just so big. And so I think we're going to focus today on a couple of specific aspects of the bill. This is a piece of legislation or a bill that was introduced. What day was it? Did it come down, Steve?
The start of June, I think June 2 or June 5, 2025.
In very characteristic style, it came down exactly 1 day or 2 days before the National Immigration Conference. So everyone was like freaking out as they were coming in. And it's approximately 150 pages. And it's another omnibus piece of legislation which means that it's a public safety bill, and it includes provisions that huge impacts on immigration law, but it also has sections that would amend. So it has sections that would amend the IRPA, and it also has sections that would amend various other pieces of legislation impacting privacy law, criminal law. What's the legislation that is the like
Privacy law?
privacy law, but like also legislation around
Oh, maritime law, like
maritime law,
Canada Post Act.
Canada Post Act, like a huge swath of legislation, all that will be amended if this bill comes into force. So
Yeah.
basically, there are lawyers all across the country who are going to have the law changed if this comes into force.
And I'll just plug some other podcasts quick, because as Deanna mentioned, we're going to be focusing on the immigration law implications. But for those who are curious about the privacy law implications or the criminal law implications, two podcasts that I follow that have been talking about those aspects of this bill include Michael Geist's Law Bites, as well as the Canadian Constitution Foundation's Not Reserving Judgment. So we're focusing on the immigration implications of this omnibus bill today. But as Deanna mentioned, it touches on multiple facets of the law. And actually in the media, I'd say immigration consequences have not been as focused as, say, the privacy law implications, and especially with regards to whether CBSA can now open people's mail. But obviously for our audience, it's the immigration implications that are of most interest.
Yeah, but it's had a really I'm volunteering with the Canadian Bar Association, as I have for many years, and the Canadian Bar Association is trying to mobilize a response. But first of all, it's had a very kind of paralytic effect because it's just so giant, and just to try and it's a change to the IRPA and to all sorts of other pieces of legislation. But as with the IRPA itself, it's kind of like framework legislation. So it doesn't specifically articulate how the act how the legislation as a whole would work. It sets out how the act would be changed, but it leaves a lot of room for regulations to be passed underneath the legislation, and we don't know how the regulations would be written. So it creates these grand authorities, but says in prescribed ways, meaning that it leaves space for the minister to then create regulations. And without knowing what the regulations are going to say, we don't know specifically how it's going to work. So this big crew is coming together to kind of draft the CBA response with representatives from the Constitutional and Human Rights section, from the Immigration section, from the privacy section, the charitable law section, like the maritime law section. So it's a huge group of people. And we see that the constitutional and human rights and privacy components impact almost every one of those areas. And there's also some recognition that the immigration consequences are the greatest one, but that there's this underlying current of changes to constitutional human rights privacy law that impacts every area. So we're kind of trying to coordinate a response, but it's quite dumbfounding to see the depth of the impacts and to try and really address those in a fulsome way with such a
Mhm.
giant piece of legislation, which is kind of the problem with doing omnibus bills, because we're not going, like, if this legislation gets studied at Parliament, we're not going to each of the individual committees. We're not going to the committee that's typically addressing environmental law, or typically addressing privacy law, or typically addressing um, constitutional law issues, or typically addressing immigration law issues. We're going to the public safety committee. So they're not necessarily
And that's
going
just
to
because the
have.
Minister of Public Safety was the one who introduced the bill.
Exactly. But this is something that we see a lot right now in the way that bills are being introduced, is that they put it, like, often we've seen in the past that things will come in through a budget bill, and then we're dealing with the finance committee, but with massive impacts in immigration and environmental law and all that sort of thing. And it's sort of like, to me, it erodes the meaningfulness of the debate that can happen at Parliament and in Senate, because you kind of want to be debating this at the committees with this, like, drill down expertise in the very specific matters. But it makes it more
Yeah.
difficult when you're dealing with just the finance committee or with the public safety committee.
Yeah. All signs point to this going to committee. I think the Carney government introduced 5 bills before breaking for the summer, and Bill C-5, which broke down interprovincial trade barriers, didn't even go to committee. It was rushed through, and it passed through Parliament and is now law. Whereas this bill did not pass in the same fast matter, so it looks like it will be going to committee. And that is part of why Deanna said there will likely be multiple episodes on this bill, because it's also possible that the bill will be amended and the
Yeah.
bill will be debated. And I'm not sure when Parliament resumes how big a priority the bill will be or what aspects will be debated. But we're here today to draw attention to the immigration implications, which are massive.
Yeah, for sure. I mean, just to start out, I'd say my biggest objection to the bill is that, for me, it runs quite contrary to the platform that Carney ran on. And yet it was clearly in the back pocket before the election was concluded, because, like, it was really not long enough between the election and the introduction of the bill for this whole thing to have been drafted post election. And so, to me, it reeks of disingenuousness, because, to me, for example, the whole, like, tough on Trump, the standing up to that, to me, that's not what's in this piece of legislation. And so I feel like, you know if people in the Canadian public understood the degree to which this is kind of conciliatory, or it plays right into what Donald Trump would like to see Canada doing. I don't know that he would have had the widespread support that he did.
I I have no idea what individual Carney voters were thinking or not thinking. What I will say is that as far as the timing of some of the measures go, one of them that we're going to get to is the ability to cancel documents. And that was actually a part of the fall economic statement that was introduced under the Trudeau government with Chrystia Freeland. And it was a one line in the fall economic statement that I immediately noticed, but the politics of the day of the proroguing and everything, kind of the fall economic statement never passed, for those who remember back to last year. But as far as this bill, it's clear at least that like the measures relating to the suspending of visas and applications is a continuation of policy that the Trudeau government was implementing. The refugee stuff that we'll be getting to, less clear, I think, whether that is more a continuation of what the Justin Trudeau government was envisioning, or if it's was concocted under the Carney administration, either during the election or in the period just after. As Deanna said, it seems doubtful that legislation of this significance would be drafted in such a short period. So I suspect that this is a continuation
For sure.
of the Trudeau government. And that's not to excuse it or anything. Like, I've seen some commentary online from some Liberal supporters to the effect of, well, this is really a Trudeau bill, not a Carney bill, which I'm not sure I buy, considering it was introduced under the Carney government. Which of the two big measures do you want to touch on first? The refugee restrictions or the cancellation of documents?
Um, let's start with cancellation of documents, I think.
Okay. What I can do is maybe encourage people who are listening to pull up Bill C-2, which is what we're going to be reading from, but obviously we are going to be reading from it. And basically what the bill does is, to keep it super simple, it gives the government essentially the ability to cancel immigration documents, cancel applications. So, for example, the legislation, the Canadian Immigration Refugee Protection Act, will be amended to say, quote, if the governor and council is of the opinion that it is in the public interest to do so, the governor and council may, by order, cancel or vary documents, including permanent resident visas, permanent resident cards, temporary resident visas, electronic travel authorizations, temporary resident permits, work permits, or study permits. They may also suspend such documents for the periods set out in the order. They can impose or vary conditions on such documents, and they can impose or vary such conditions on temporary residents for the period set out in the order. So
This is in
that's
Part 8
huge.
of the Act, by the way, in case you're trying to find it. So we're talking, I can't see your screen to see exactly, we're talking around Section 77 of the
Yeah.
bill.
And the governor and council can also make an order to suspend the processing, essentially, of any applications.
So we've seen various iterations of the government either just doing such things, like with the cancellation of ETAs for Mexican nationals, which they did. It's funny that they're like giving themselves this power when in fact they've used this power, which kind of makes you wonder if they're like they've clearly, it
ETAs,
wasn't
I think
done.
they always had the ability to cancel. I think that was unique to ETAs in certain circumstances. I remember researching this at the time that they
Okay.
brought in the cancellation of the Mexican ETAs. It's all the other documents. And
Yeah.
it wasn't just in like public interest. That was, for those who are wondering what Deanna is referencing, it's when in February 2024, the Canadian government imposed a visa requirement on Mexican citizens and canceled existing electronic travel authorizations of Mexicans.
And what this meant in real life is like some people were literally mid-air in flight on the way to Canada when their authorization expired and they had no notice of that. And then when they arrived in Canada, they arrived and were told, no, I'm sorry, you didn't have authorization. And so, again, this is the kind of shenanigans that we as immigration practitioners have been dealing with, in recent times, and why we all look a bit harrowed. But this is a really massive expansion. So, I mean, that's the first point to be making here, that the cancellation of all these documents right up to and including a permanent resident card. So, it's massive. And I mean, I keep making these very alarming comments on my LinkedIn page, but again, I do want people to really understand the enormity of this. The part that I would like to specifically emphasize is where it's in the public interest. And so you can't really get much more vague than that, because who determines what is in the public interest? And so this takes me back to what was said in Mason, which is a case we talk about so frequently, is that when a massive loss of rights and privileges arises from a provision like this, and there's no nexus to a very specific wrongdoing that somebody is proclaimed to be guilty of, I see real charter problems here. The issue is that when it's done by order in council, there's all sorts of cabinet privilege that arises, which means that, like, who is going to review that type of decision? It's sort of like immune from charter scrutiny, because decisions made by order in council are not transparent, and we wouldn't have the ability to, like, review the decision in the courts, for example. And so it's kind of creating this unreviewable type of decision that sits behind that wall of scrutiny. And so it's kind of doubly alarming from my perspective, because generally speaking, a decision like that that's made at the level of an officer, we can take to federal court and say that was unreasonable. That was, this is not what is this is not immunized by kind of this kind of broad claim to public interest, and this is not charter compliant, or whatever the case may be. But it's everything that we are seeing kind of generally accumulating, the inability of applicants to actually have insight into why their application was actually refused, and to have that actually scrutinized by the courts for charter compliance and compliance with international law, yada, yada, yada. So,
Yeah.
and a lot of those decisions have been getting overturned by the courts. And so just because, like, a bar fight is not an act of terrorism, for example, giving the example of Mason, and again, I think lawyers are getting a lot of flack for, like, we are supporters of terrorist activity and all that sort of thing. No, I think this is a situation where we do want the courts to be able to say that while we believe that there should be legislation preventing terrorism, it should not be applied to somebody who gets into a simple bar fight.
Which is essentially what Mason was. And we'll have
Exactly.
to link to that. But we
Again.
can link back to that episode. The government, in response to some concerns, put out a press release that tried to explain more about what Bill C-2 does with respect to this. And it says, quote, "The Strong Borders Act would allow the government of Canada to cancel, suspend, or change immigration documents, and to suspend, cancel, or stop accepting new application when it's determined to be in public interest. These measures would improve our ability to respond to crisis and unexpected events by updating how we manage immigration documents. Public interest can include, but is not limited to, risks to immigration or program fairness, safety, security, and health risks to Canadians, misuse of government programs, large-scale emergencies." So it doesn't, and they specify that it doesn't apply to asylum claims.
But none of
So
that is in the legislation, and that is
I don't even think
really,
any of that really clarifies any of the concerns that people
no,
have either.
not
I always
really.
love when they say public interest can include but is not limited to. So
Right,
it can
exactly.
include anything. So, I mean, there's a lot of uncertainty here about what they are targeting and why they feel the need to do this. I'll just give some examples of different things that people have been hypothesizing. Again, I want to just stress this is hypothesizing. The government has not actually specified that any of these programs will be canceled. For a bit of the history of the canceling of programs, under the previous Conservative government, legislation was introduced to terminate, I believe it was, I can't remember if it's 1 million skilled worker applications or people who were part of applications, as well as the federal investor program. That was done through legislation. So is this bill being introduced to cancel applications wholesale in programs? Some people have mused, and again, this is just people musing, that this may be applied to could it cancel the self-employed class? Could it cancel the startup visa class? Both of which have backlogs that are massive given the size of a admissions target each year. The other scenario that we talked about on the podcast a few years ago was in 2023, the government introduced a policy to bulk approve temporary resident visas for people who had applied before September 2021. And a lot of people, including myself, thought that's a bit of an odd way to handle the backlog. At the time, I guess, they felt they didn't have the ability to cancel visas. Maybe this is for that. The cancellation of work permits and documents, I don't know. I mentioned before the Canadian Constitution Foundation's podcast. They mused, and it was the first time that I had thought that this could even be a thing. The government, as we know, has a target of 5% foreign workers or temporary residents in Canada by 2027. Could this bill just be used if that target is not met in 2027 to just bulk cancel documents to then say target met?
Yeah.
We
The
don't
thing that's
know.
crazy
And when
though,
would
Steve,
PR cards be canceled on?
I
Like,
don't
there's just
know.
such uncertainty.
The thing that's crazy though is that you reference the cancellation of the federal skilled worker backlog. They did that under existing legislation, and lots of people complained. There were numerous class actions that were filed, and all of them were unsuccessful.
Mhm.
So the
Well, they had to
fact,
pass legislation. They had to get that through when they terminated the skilled worker backlogs. That was through amendments
get it,
to
but
verify.
it
Yeah.
was successful.
Hmm.
So the fact that they are now trying to create an like they need to do it by order in council, so they don't even need to go through the process. Like, it's not like the mechanisms that they have don't exist and aren't successful. They just want the ability to do that without any
Yep.
like they're trying to just
And
like
you've talked about this. Like, it's kind of the extenuation of going from passing legislation to ministerial instruction.
yeah.
Here, they don't want to go through the passing of legislation. Instead, they want the ability to just be able to cancel applications.
Yeah, I mean, the thing that sort of boggles my mind is this seems to me to be absolutely um ripe for a constitutional challenge. Like if they were to try and if this legislation doesn't get amended, to me the idea of trying to absent these types of decisions um, from any type of judicial scrutiny, specifically in light of the decisions that have been made in Mason, and in light of the fact that it's kind of reversing so many previous Supreme Court of Canada decisions, says to me that this is kind of begging for a constitutional challenge, maybe several. And so I just
I
feel
have
like,
no idea what it is they want. It's hard to. That's the thing, right? And I'm take the position that until they actually give an example of what it is they want to do, it's reasonable to assume that, if I'm a startup visa, I'm going to regret saying this maybe, but if I'm a startup visa applicant, I would be very nervous about this legislation. If I was in the self-employed queue, I would be nervous about this legislation.
I think regardless of this legislation, I would be nervous in either of those categories right now.
Hmm.
Um, you know, there are lots of categories that I would be nervous in right now, to be honest. I would be nervous in the caregiver category. I'd be nervous in the parents and grandparents. I think that the department has shown a real distaste for certain categories. And it's almost like their processing um, demonstrates a real lack of good faith in terms of the way that they're processing them. And I think that um, that's really it. I mean, I think that there does seem to be a demonstration of lack of good faith. And I think that to me, when I look at this bill overall, I know we're all very interested in talking about what's happening south of the border, about like the idea of um, the enlarging of government powers, the enlarging of the powers of the state um, to just make law without any public participation, without any ability for the state, like for the public to say, no, 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 that's too far. But I see this just simply as allowing the enlarging of public power with like a reducing of the democratic. That's it. Like it's
Yeah.
just
I like how you also say an enlarging of the power of the state, because whenever it comes to these things, people who may support a measure often always assume that the political party that's passing it will always be in power.
exactly.
And I just, for Mark Carney supporters, and there seems to be a segment of the population who think that Mark Carney is the greatest thing since sliced bread, would you be comfortable with the conservatives or a Pierre Poilievre having the ability to
Yeah,
essentially cancel all immigration applications?
for
Because
sure.
that's what this bill does.
But not just immigration, like with the now you would have all of these powers of search and seizure of like that Canada Post would now like the changes to the Canada Post Act. So I think that people are like, oh, immigrate, like even if you have that, okay, I don't think that immigration should be it's too big, whatever, but there are far reaching
Mhm.
um, changes that go into the criminal justice stream, that go into like what happens now if your child is subject, because there are changes that result in like lower thresholds for when they need a warrant in order to be able to get documents from crown corporations, for example. I think that like they're talking about an overall broad-based reduction of these thresholds. And so it's an overall, and I say to myself, as a person who does actually believe in democracy most of the time, unless I become queen of the world, which is that like why do you want to shy away from that kind of scrutiny? Why do you want to shy away from judicial oversight? Why is that considered a bad thing in what is supposed to be a constitutional democracy? That just kind of that bumps for me.
Yep.
I know it
Let's
has to be passed, but yeah.
let's switch to the refugee changes, which are the other big change, and which, even though the bill has not yet passed, are already in effect.
Yeah.
You go
So
for it.
yeah, maybe let's start with the why are they already in effect? Because I don't know about you, but I think this is the first time I've ever seen this where when they when they announce or propose a piece of legislation, they have to have transitional provisions. And what that means is like if and when this bill comes into force, when will it become active? And so these transitional provisions are written in such a way that the day that the bill was introduced, June whatever it is, on that day, if it comes into force, it will be effective as of that day that it was proposed. So basically, what the rule says is that if a refugee came into Canada after June 24th, 2020, and didn't make an asylum claim within 1 year after their arrival, then they will not be able to get referred. Their claim will not be referred to the IRB. And so they will essentially be prevented from making a refugee claim. Instead, they will get a pre-removal risk assessment. So this, by the way, is at it's part 9 of the bill, around section 78. Yeah, that's where you are. So, um, so firstly, I just want to make the point that some of my strongest refugee claims have been made by people who have been in Canada for many years. And I'm talking about like cases that were so manifestly well founded that they were decided on paper. And I'm talking about like women from Afghanistan, like really, really patently justified claims. And the reason being that because of how trauma works, if people have an economic pathway to permanent residence, they will take that any day rather than having to revisit the trauma that they experienced in their country of citizenship. So, this automatic connection between delay and bogus is actually not true. It is true sometimes, 100%, but it's not logically linked. And actually, this is a linkage that is established again by Supreme Court of Canada jurisprudence. And Barbara Jackman was like, we got to see her in person at the immigration conference. Like this was one of the first Supreme Court of Canada decisions. I think it was Suresh that she got that precedent
Singh,
established.
Singh,
Singh.
RV Singh.
Thank you.
Yeah. It's a
Um,
1986 Supreme Court decision, I think.
I'm really bad at remembering names, so case names. So, but that's why I rely on Steve. So again, and like the idea that this now, her first Supreme Court of Canada decision, which is for an important principles, delay is something for the Refugee Board to consider, but it is not an overwhelming consideration. It's not an like that is not a basis to singularly refuse a claim. There are factors that the person needs to consider, and this legislation overrules that entirely. And the government keeps saying, well, but you still get a PRA application. But anybody who's ever made a PRA application as compared to a refugee claim knows that a PRA application is an incredibly poor substitute for a refugee claim. Most often, there's no oral hearing. If there is, the interview at a PRA application is, again, a very poor substitute for a fulsome refugee claim where you bring witnesses and you have a full interview, and it's not an adequate substitute. And also it's up to the discretion of the officer whether or not to have a live interview at all. And so it's just not a sufficiently mitigating factor that they've put it this way. The refusal rate of PRA claims is just astronomically higher than the refusal rate for refugee claims. And
It's
so,
also not clear how they'd get to PRA. Like right now, for a refugee claim, someone can claim asylum right away. Like at any point, you just go online and you can file an asylum claim if you're in Canada. A pre-removal risk assessment is kind of predicated on the idea that there's a removal order in play. And it's not clear to me how someone in Canada currently with a work permit or a study permit, in theory, to get to PRA would have to first get themselves in a situation where there's a risk of removal.
correct.
So I don't fully, it's not clear to me whether that process is going to change how one applies for a PRA, because it seems like there's going to be a lot of stumbling around in the interim. The bill, and I always get asked this, are you sure the bill is already in effect? And as Deanna mentioned, there are transitional provisions that, for those watching our YouTube, are up on the slide, which state that the bill essentially took effect the day that the bill was introduced. I don't,
Assuming
I
that it
can
gets
think of
passed in
other,
its current form.
I can
Yeah,
think of other, I mean, I'm pretty sure that Harper, like when immigration reforms are introduced, it's often the case that transition provisions take effect immediately to prevent a flood of applications. It's not
yeah,
just limited to immigration. I'm pretty sure that the Liberals last year, when they introduced their capital gains tax increase, made it so that that took
right.
effect with transitional periods immediately. But, and this could happen with Bill C-2, that capital gains hike never actually passed.
Hmm.
So there had to be this weird unwinding of taxes that were paid essentially. And it's, whether the same happens with Bill C-2, if there are changes such that claims that are being made now that are not supposed to be ineligible, if they change this, will become eligible. There's a bit of a question there. I think you also referenced the Singh decision. In light of the Singh decision and in light of the Refugee Convention, I have a hard time seeing how this withstands
Yeah,
charter scrutiny.
me too.
I have a hard time envisioning the Liberals imposing the notwithstanding clause. And so to me, it almost just feels like the government hitting pause, knowing that they'll probably have to undo it later, but also knowing, like we've talked about, like there's 300,000 odd Ukrainians who are in Canada, who have been on Canada on CUAET permits, who probably would have a pretty good chance at asylum. There's 60 to 80,000 Iranians on open work permits who probably have a pretty good chance of asylum. And of course, all the issues with temporary residents who are losing status, who may not have as good a claim of asylum, but may be incentivized to file anyways. And it's just a bizarre, I would call it just, it's an unconstitutional, likely unconstitutional pause,
Yeah,
because otherwise they would be flooded.
yeah.
1% of Canada's population right now are asylum seekers. And I think the government is just hitting pause in a likely unconstitutional way.
And also, like, in the meantime causing like massive havoc in people's lives. Like this is not, and I feel like it's really stoking the fires of, um, racial intolerance and, because I think, I've just heard more like anti-refugee, anti-immigrant rhetoric than I can remember in Canada's history. But, it's not for lack of people really. Um, my experience has been like doing the refugee work is that people have no desire to become refugee claimants, and that's, I think, it's not sort of like, oh great, I get to make this claim. Like it's a really unpleasant process, and it's a lot of people have strategically avoided making a refugee claim. They don't wish to. They have decided they would like much prefer to earn their permanent residency. And being forced to go this route because all of their other options have been cut down because of the way that the economic opportunities have been disappeared is really demoralizing. And yet people are like, really desperate not to go back to the place where they really are in fear.
Yeah.
Um,
It would be nice if there was more of an articulation as to what the concern with the rise in refugee numbers are, so that measures could be introduced to actually address that. Because as you said, like somebody being in Canada for a year before applying isn't really a good barometer of the
no,
legitimacy of their claim. Like
yeah,
if the concern of someone is that, they just don't care if someone faces persecution back home, that's a values judgment. I'm not going to that's a whole other discussion about just value versus value but the government hasn't articulated that.
no,
If
for
the
sure.
concern is fraudulent refugee claims,
Then go for
then
fraudulent refugee
I
claims.
would
Eliminate
love
those,
if that's usually facilitated by unscrupulous individuals and go after them.
for
And
sure.
go beyond just like revoking a license to practice law or
Prosecute.
prosecute. Go for civil forfeiture. Honestly, like I'd
Totally.
love to see massive consequences on that.
Me
If the
too.
concern is that it's a drain on, like, refugee claims are a drain on finances, there's probably ways to mitigate that through, I don't know what it would be, but like some sort of, there's just either not necessarily charging for it, but, and again, this is going to be controversial, but if the concern is fine, like my point is, if the concern is finance, you can go for some sort of a paying back, some sort of a fee that's paid for ages after, maybe once someone reaches a certain threshold of income so that they're not constantly in debt. Not necessarily endorsing that, but saying at least if there's a finance concern of Canada's finances, there are ways to address that. The
Yeah, it's really
prohibiting of
odd.
refugee claims after a year doesn't seem connected to any problem beyond what I said, that there are a lot of people who may claim and they just want to hit pause.
Yeah. But, in terms of this economic piece, um, I understand how it works with humanitarian applications abroad. I think there is more of an economic commitment that Canada makes in respect of those claims. But when you think about in Canada claimants, I don't think I'm being that naive, but in terms of the settlement services that they're actually offered in Canada, they're pretty darn lean. It's not like Canada's offering settlement, like huge amounts of settlement funding for them. The services that are available have mostly been cut off or eliminated. Most of the clients that I represent have 2 and 3 jobs in order to kind of support family
Yeah.
members, like, um, I'm really struggling to see where the drain comes from.
Um,
The
I mean,
alleged
how
drain.
much of this is refugees or not, I'm not sure. I think the government yesterday announced something like 3 billion in funding for 500 organizations over the next 3 years. What percent of that goes to refugees? There's actually a percentage of it apparently that goes, I'm bringing it up, but helping francophones settle an area outside of Quebec. Um, there's also, I think the Ford government said that there was something, or it was either the federal government or the Ontario government had hit $1 billion for hotels for asylum seekers. So I'm prepared to say that there is a cost there. How you would individualize it and how you would address it, if that's the concern, is something that could be discussed. It's just I don't think this bill and the measure being proposed actually addresses that concern.
Agreed.
Um, you wanted to talk about designated reps?
Oh, yeah. One of the
Oh,
other,
the other one, just before
yeah.
we talked about the 1-year bar. The other big thing the bill does is the Safe Third Country Agreement between Canada and the United States was amended last year or 2 years ago so that people who cross the border irregularly would be encompassed if they claimed asylum within 14 days. That created this weird incentive where people would just wait 14 days and be underground essentially for those 14 days and then claim asylum. They also will not be eligible to have their claims heard by the RPD. So essentially anyone who's not an American who crosses the Canada-US land border will no longer be eligible to have their refugee claim heard.
And this is, I mean, again, the Safe Third Country Agreement, just simply put, calling the United States a safe third country right now for foreign nationals living in the United States should just make anybody shake their head, because, I mean, we all know what's happening to non-nationals of the United States who are living in the United States, especially when they're potential asylees. I'm literally every day getting calls from people who came to the United States with the intention of making a refugee claim and now do not wish to make an asylum claim there for fear that they're going to be taken to Guantanamo, to the desperate prisons in El
Yeah.
Salvador. It's just a
This though,
terrifying
this
prospect.
isn't an amendment to the safe third country. This is just they're not eligible for PRA. They're not or not eligible for their claim to be sent to the RPD. They're
I
not
get that
being
it's not
returned
an
to the United
amendment.
States, right?
No,
They're
I
not.
get it.
Yeah.
But it just means that it's a further barrier to actually
Hmm.
electing to make their claim in Canada because the United States is not a safe third country. And the worst part of it is that people because I know there are routes that people take from Africa, from Central South America to Canada, that they don't have any option but to go through the United States. And people that are on that route will not know that they cannot do that anymore. For the most part, they're not checking the internet on their way. And so they will arrive thinking this is still a viable avenue and find that, in fact, that door is closed and they will not have the ability to make a claim in Canada. And so,
Yeah.
yeah,
Safe third country agreement and the principles behind it are being litigated. Again, this is going to be subject to obvious challenge. I think the government probably expects that it will be struck down, and it's just a big way of saying pause.
pause. I totally agree with that. I mean, it was struck down at one point and then reinstated on appeal. So again, it just feels like an oddity. And that was before, when things
Yep.
might arguably have been called safer.
You wanted to talk designated reps before we go to questions and comments.
Okay, so there is a mechanism within the Immigration and Refugee Board for a designated representative to be appointed. It's a great idea, but it's flawed in some ways because essentially what it is that if somebody does not have capacity to represent themselves, a designated representative can be appointed to be kind of like a guardian ad litem, so that it's like ad litem, so that if a person doesn't have capacity to represent themselves, or somebody doesn't have capacity to give instructions to counsel, a designated representative can be appointed. But so this bill has introduced provisions, and let me just figure out exactly where it is. It's at section 36, where it sort of enables kind of automatic appointment of designated representatives in certain circumstances. But the issue here is that, first of all, not all designated representatives are created equally. Some are extremely sophisticated and nuanced, and are able to do the kind of trauma-informed work, or able to do the sophisticated work necessary to offer really good substituted kind of instructions to counsel. But I think anybody who's worked with designated representatives knows that it's like, and the board, I think, really struggles to find designated representatives who have the sophisticated skills necessary to do this piece of work. So that's part of the issue. But also, there are some situations in which the appointment of a designated representative can prejudice a claimant, because it kind of concedes that they don't have the capacity to run their own lives, and that sometimes can create a negative, it can cause the decision maker to cast negative aspersions that is not helpful to them. And so I just think that this needs to be run very carefully. And again, it could end up being a negative thing for the claimant, depending on how it's run. And so it's sort of like, it could be a good thing, it could be a really bad thing, just depend on how it's run. So it just makes me nervous when I see that that's subject to potentially regulations that we don't yet know about, or even a policy that we might not have that much input into.
Yep. And just also, I guess, quickly to round it out, going through some of the other changes, the Act is going to be amended so that the Immigration Division cannot hold an admissibility hearing if someone is not physically present in Canada. That may seem obvious, but I have actually represented people who were outside Canada during their admissibility hearing. And there's even a local CBSA inland enforcement officer who's very helpful in these claims or types of situations. And I'll give a scenario and just say that hopefully, if they're getting rid of the ability to have these admissibility hearings, some other process will be developed. Because what sometimes happens is somebody, say, will be told and get a letter saying, hey, we are referring you to the Immigration Division to determine if you committed misrepresentation, and the permanent resident or foreign national will just leave Canada. They might not even be aware of that letter. They then miss their admissibility hearing. A warrant goes out for their arrest. Years later, they're saying, hey, can I come back to Canada? CBSA is saying, there's a warrant for your arrest, and we need to figure out how to get this admissibility held because it's required under the law. And then you need to get proof that you actually left Canada. And it's this whole complicated thing. So you wind up just doing it where they are remote outside of Canada so that they can get their exclusion order. They can then confirm their departure. The 5-year misrepresentation clock can start. So all I'll say is that if they're getting rid of the ability to do these types of hearings in abeyance, there hopefully will be some other mechanism brought in, because then you just wind up, if not, you wind up with A, active warrants for people's arrest.
Mm-hmm.
B, you continue to have the Auditor General come out with these reports being like, CBSA has lost track of where people are, when often it's obvious they're not in Canada, but there's no way to really recognize that because of the certificate of departure requirement.
Yeah.
Other things that they are doing, simplifying the online application process. I recently did an asylum claim, and I can confirm that it sucks, the online process. I was commenting to people being like, wow, I thought that the forms for sponsoring a spouse were a mess. You can't even, like, 3 people can't even do their refugee claim online at the same time. You got to go through one all the way and then the next. God forbid if you have like an apostrophe that you want to put in a form somewhere. Refer, they will be this one. There's a Twitter user, Ghosts of CIC, has talked about on Twitter, referring complete claims to the IRB to speed up decisions. Why that has to be the IRB instead of IRCC.
We don't really understand fully what this means, because we don't have insight into how this mechanism currently works. But anyway, Ghost of CIC feels that this is very problematic, but I think that we don't really understand enough about what the problem
is. It just seems
is.
like it's one versus the other.
Yeah.
One budget will be increased for one department. So like,
Yeah.
or one department will get more responsibilities without a budget increase. Not
We
sure.
also haven't talked about the extraterritoriality rules, which to me send chills up my spine. That's at section 75. I don't, again, this to me seems like the sleeping monster, because I don't know what it means, but I fear that what it means is that it would permit officers who are stationed abroad to conduct examinations. And I have already observed through my practice that there are like CBSA officers who are working um, at airports, like they're being stationed at airports, um, and that when they're seeing, like, I've seen applications reopened essentially, um, once the airport, like the airline official eyeballs the claimant at the border. I feel like, because we know that there are liaison officers that are stationed outside of the country, this gives me the heebie-jeebies because I feel like they're going to like re-adjudicate applications. And I have seen that
They
happen.
do. So it could just be that maybe somebody wondered, hey, do we actually have the authority to do what you're already
Exactly.
describing?
Yeah, and so I feel like, I've been talking in my kind of panicky way about things that I've heard through the Rainbow Railroad about, like, this person looks like they might be gay and they're coming from a refugee producing country where there's a high ratio of positive claims coming from SOGS claimants. And to me, the idea of preventing somebody who likely has a meritorious refugee claim based on somebody profiling them at the port of entry is a real problem. And so to me, I really, I get my hackles up around this provision, although I just really don't understand what it means because it's so vague and lawyery that, like, but
Yeah.
anyways.
Okay, let's get to some of the questions that
Yes,
we
please.
got. How likely is it that Parliament will pass Bill C-2?
Good question.
Very. It's in my opinion, it's 100% likely that it will pass. Whether it gets amended is what's up for debate.
This is, I totally agree with you, Steve. And unfortunately, the way that it got passed and then the way that they like
It hasn't
sought,
passed.
sorry, the way that it got introduced,
Hmm.
I should say, this is my Freudian slip, the way that it got introduced and the way that stakeholders got asked for feedback to me represented like, so that they could check a little box to say that there had been a briefing, but like people had 24 hours notice, not even 24 hours. I think it was actually 12 hours. And so, like, even, the chair of the immigration section hadn't even, like, she was in a mediation all day long and hadn't even seen that it had come out before the briefing had actually been held. Like, I don't see that this is actually an intention to have meaningful engagement with key stakeholders. We're preparing, trying to do something, but like, I'm just not feeling lately that there's like true engagement. There's a true level of engagement with key stakeholders to discuss things like this. I feel like it's like a push, push, push.
Yeah. It's important also to remember the Liberals are in a minority government, so they will need some of the other parties to at least back them on stuff. As far as what gets amended, the immigration implications of the bill haven't seemed to be what's getting the most attention. It's mainly the privacy stuff. So
I don't see why they
I'm
would oppose, though. Like, this looks like a conservative bill. Am I right?
only when they're in government. When they're in opposition, it does not. So like that's always how it works, right?
It's just politicking.
Yeah. Although there's a libertarian bent to a certain large part of the party, I would imagine, the Conservative Party, that would have a problem with some of it.
Okay.
But yeah, I'm not sure what amendments will be brought in, just because there haven't, at the political level, seemed to be too much scrutiny of the immigration implications.
Yeah.
Will Bill C-2 result in loss of permanent resident status? So no, they aren't amending the part of the act that deals with status.
But
This is
they're
part of
allowing
what
for
the
cancellation of
confusion is,
PR
right?
cards.
Yeah, like
Yeah.
exactly. So they'll be canceling cards, which can be used to travel to Canada and be proof of status.
But maybe that's
But
exactly it. They're like where I don't get it. Like maybe where they believe that people are non-compliant with the residency app. Again, I don't know. Like I'm just speculating, but I don't understand why they would be giving themselves the power to cancel PR cards.
no, and that's part of the question is what does it mean if your documents are canceled? Does that impact your status? It's just not clear.
It's
It's
just
very
not
odd.
clear. Because honestly, like as it stands today, you can't have your PR card cancel unless you've extinguished an appeal at the IAD.
Yeah.
But
So
maybe that's it. Maybe it's just because if you don't return that card, there's still a card floating out there. Maybe that's all
yeah.
it means, but we just don't know.
Ghosts of CBSA says this isn't the first time. I'm assuming Kenny did this with the 2012 changes. I swear I didn't read that comment before I referenced Kenny making the changes
Mm.
retrospectively.
No, he just remembers
Um,
everything.
Ghosts also says, why does someone who isn't required to leave need protection? They are encouraging other avenues. I'm not fully sure what that's in reference to. If it's in reference to my comment about PRA and why isn't someone who isn't required to leave need protection, what I would say is it just seems very inefficient and odd that, let's say you're a work permit holder in Canada and you want to make a claim for protection, that first you have to get yourself out of status or somehow get yourself to the attention of CBSA to get a removal order, which can be complicated if you're inside Canada. So I don't know if the expectation is that a work permit holder will show up at CBSA and be like, hey, I have an intention to be a permanent resident. Can you?
I think it will happen in a
I
whole
think that
bunch of
still has to
different
go to
ways.
the division, right? So they got to there has to be some way that like won't have people kind of languishing weirdly where they're thrown out of, like they just have to get to the attention of CBSA. And it seems like a very inefficient process.
I think what will probably happen, and again, I don't know, they're going to have to set up a machinery because otherwise what will happen is they'll make a refugee claim. They'll be told they're ineligible to make that claim. But at that point, there will already be a removal order against them
Is that the
because
idea
of
that
the
they
failed
still have
claim.
to claim?
I don't know.
Yeah.
But I don't think our suggestion is that they won't be under removal order. Of course, they will need to be under removal order. I think Steve's question was, how would they get there? And they
Yeah.
can get there in any way, but of course, they would need to be under removal. It's just like, it's kind of strange to have to like get yourself under removal in order to be able to make the PRA application.
Yeah. More from Ghosts. You're being naive. Canada has spent
Won't
billions
be
in
the first time
housing
I've
over the
been told that.
last couple of years. Yeah, we call Deanna gets called naive about once a month on the podcast.
Oh, once a day.
But no, but I mean, look, like I think I mentioned that as well. That I think some government, I can't remember if it's Ontario or the feds, have hit $1 billion or something. But if that is the concern, I think there's just other ways to address it through some sort of a cost recouping rather than just declaring someone ineligible to the IRB. Whole other discussion. I could see Deanna grimace when I said cost recouping, but it's a whole other discussion. This is sort of unrelated to the topic at hand, but we'll answer it, which is why is it taking so long to process HIRV applications as people are waiting for visas for 3 years? And why having US UK visa not help Canada determine HIRV cases for inadmissibility? HIRV means human and international rights violations.
Hmm.
So all I would say is Canada is a separate system. So why it takes so long, I would love to know why the security screening takes so long. I assume it's just a question of resources. And also they don't do first come, first serve, which is clear. So yeah, we've talked a bunch about that. So I'm not going to get too much into. You can listen to any of our episodes on mandamus, processing delays, but the security concerns are causing huge delays.
Yeah.
This one, we got a paid one, $40.
Wow.
Roxham Road. That is, I think Roxham Road's largely been closed, was my understanding, and that there's just other routes now. Um,
Yeah, I think the only thing I would want to add on Roxham Road, it seems like, I don't know if that's just because it's a YouTube, it came in from YouTube, or if there's an actual video there. But one thing I would say is that the whole problem with the way that the Safe Third Country Agreement exists, the problem that it creates is that people have been forced to take more dangerous routes in order to be able to try and avoid the exclusions that were created by that agreement. And yet, you know, it's a funny little agreement because it's like if you arrive by air, it doesn't apply. But if you
yeah.
arrive irregularly, you know, and it's sort of like, huh?
Yep. Last one back to Ghosts, who's listening live. I don't think there's any desire to cancel PR cards. This is for visas. What I like about this comment is that it kind of gets to what we were saying about what's the point of this law, because the law does 87.302 will give the authority to cancel PR cards.
Yeah.
So if there's no desire to cancel PR cards, the
It
question
shouldn't be
becomes,
in the
why is it
law.
in there? And presumably it's being included for a reason. That's it. Thanks everyone for asking questions. And as Deanna said, we'll probably be doing subsequent episodes
No doubt.
on this. Awesome.
We appreciate you.